talk on human trafficking and modern slavery offences. Modern slavery now is arising on a very, very regular basis in so many cases that we do, that it now is an inescapable part of the criminal justice system. And Szilvia Booker and Richard Jory are going to give us an insight based on some of the based on some of the cases they have done into human trafficking, and update us on modern slavery offences. So take it away.
Well, can I just add one tiny thing to that? This probably is about exploitation. I'm going to make Richard Jory QC very cross by telling everyone, but he's having to work through his birthday today by joining me in this presentation. So can I say an extra special thank you to him? And I have promised him that at slide 12, he can actually go and celebrate, but not until then. And in case any of you thought that the headline somehow related to the profession, because we all, I'm sure, feel exploited, I'm afraid it's not going to lend any assistance to billing claims or having better working conditions. But whether you defend or you prosecute trafficking cases, thinking about charging, thinking about post-charge, even at the interview stage, if you're defending, you really need to be aware of the progress in this area that has been made, and absolutely fresh case law that is now guiding a complete sea change, particularly from the pushback that we saw from the judiciary on the 16th of February 2021. So literally fresh off the presses, an absolutely brand new case has come to dominate, and we'll come to that. But there have been developments in policing, evidence gathering, joined up methods for protecting victims. And the bottom line is, just as it says on this slide, how is the criminal justice system now dealing with that fine line between a person's status as a victim and as an offender? Got to go back to brass tacks if you want to understand this entire area. There is now a very settled definition of what human trafficking is, and it's maybe easiest to think of it in the way in which the conventions, the international conventions, are asking people to think about it. It's actually a process in which there's an act, and it's in a particular way, people act in a particular fashion, and ultimately for the purpose of exploitation. So the act, that means the traffickers are recruiting victims, they're transporting them, they're harboring them, hiding them from authorities, or they're receiving them from other traffickers. And lots of people, particularly if you're on one side of this as opposed to the other, questions often asked, well, why don't the victims just run away? They don't like their working conditions, they don't like the pay, why don't they just go? That's because traffickers use different means to compel compliance. In other words, they get their victims to do what they want, sometimes without threats, sometimes without locking them up physically. They do it by befriending them, grooming them. There are other types, other means. Sometimes they get threatened, they do it out of compulsion, or they threaten members of their family. So they feel that if they disappoint their traffickers, then revenge will be sought not on them, but on members of their family. And why are traffickers doing any of this? Well, this is apparently, and it's really hard, obviously, to get statistics, but it's a massive $3 billion enterprise worldwide. That's why they're doing it. They're doing it to take advantage of victims for profit. Different forms of slavery and trafficking offenses, the type of exploitation that we're most familiar with in the cases that have come before the UK courts generally tend to be the commercial or the labor exploitation. Often it's public facing. You have nail bars, restaurant staff, car washes, or it can be in the supply chain. You can have it in the agricultural sector, food processing and packaging, or the garment sector. Those have all made headline news. And they're not limited to centers of industry that are far flung. You have them in city centers, you have them in London, you have them in Leicester, you have them everywhere, and they're right under our nose. It's incredible. Another area which is quite prevalent and also well advertised is sexual exploitation. This is all about the brothel work. This is about girls predominantly, but you have other genders being brought over, put under debt bondage until they pay it off. Sometimes they never pay it off. And so sex works becomes what this offense is all about, which is a denial of personal autonomy. If a sex worker is coming here by her or his own steam and wants to do this work, more power to them. But if they're coming here because they've been promised a better life, they've been promised better working conditions, and then what they find is that those better working conditions, better clients, actually never money in their own pocket, then that personal autonomy is taken away. Other forms of exploitation, you have organ removal, that's specifically catered for in the legislation. But you have other things like criminal activity. We'll come to this in the presentation, but it's not just for those offenses for which there is a statutory defense. Increasingly, what the courts are seeing is that young people in particular are being used for violent offenses for which there's no statutory protection, robberies, home invasion, burglaries, etc. There's also false immigration or sham marriage reasons for exploiting people, and of course, securing the services of children, which Richard will speak about, the distinction in the legislation. Child begging, a big area where this is on the up. And so wherever there's people, there's going to be new and creative ways of exploiting other people, everything from benefit fraud, orphanage fraud, illegal adoptions. It's all on the up. And so what you have is a very progressive response to that in Britain. And so can I invite Richard to explain to you the Modern Slavery Act?
So basically the Act is divided into 7 parts, and it covers offending and also other related matters, so civil orders, penalties, etc. And just as a bit of background, it seeks to reflect efforts on an international scale to stamp down on and to prosecute the rise in cases of exploitation and modern slavery. And it's the first legislation of its kind in this country aimed solely at modern slavery. And it repeals and replaces statutory offences contained within other pre-existing legislation. The fact that legislation makes reference to and borrows terms directly from Article 4 of the European Convention on Human Rights, and Article 4 itself borrows phrases and terms from earlier protocols, has the practical effect that much of the case law predating the introduction of the Act remains relevant and applicable, and that's important for reasons we'll come on to. So the main offences you can see on this slide, section 1, and we'll just stay on this for the time being, are contained in section 1 and section 2. And here you can see the beginning of section 1 dealing with slavery, servitude, and forced compulsory labour. And one curiosity in the whole of the Act is that there is in fact no definition of the main terms used. But what you can see is that cases have clarified to a significant degree what constitutes slavery and servitude and forced and compulsory labour, and they're all separate matters which have to be considered in turn. You can see how the draftsman in section 1 has simply said it is an offence to hold another in slavery or servitude, and then in quotes, and the circumstances are such that the person, that is the defendant, knows or ought to know that the other person is held in slavery or servitude. So that's subsection 1A. And if you then look down at 1B in precisely the same terms, but in respect of performing forced or compulsory labour. Then go below that, you can see further at subsection 1.2, the legislation refers explicitly to Article 4, and that interpretation of these terms should be, again in quotes, in accordance with Article 4, which prohibits slavery and forced labour. and then section 1, subsection 3, in making a determination, regard may be had to all the circumstances. Now, we haven't copied thereafter subsection 4 and 5. They're not on the slide. They deal with other matters, for example, personal circumstances. They make clear that consent by the person performing the work or being exploited does not preclude a finding that that person is being held in circumstances that might amount to an offence. And there are exceptions which are also set out, for example, if you're working in detention or in the military, and certain other measures and actions taken in an emergency. So slavery, what is slavery? You can see it there set out, but in simple terms, and just staying on the same slide, slavery would involve a situation where one person exercises any or all powers of ownership over another. So just thinking about that for a moment, it's going to be a very rare situation where you find yourself dealing with, either prosecuting or defending, a case involving actual slavery, although of course all of these terms come under the heading the Modern Slavery Act. So just be conscious of that. And there are some useful cases that address these distinctions. Cases including predating this act. So 10 years before this, in a case called Szilvia against France, 2005, the court determined that that in considering the potential offences, you should look at all the circumstances. And you'll notice that Szilvia referred to considering all the circumstances. Look again at your subsection 3. That's been replicated in the statutory provision we now have in the UK. And essentially in that case, Ms. Szilvia was a national from Togo. She came to live in Paris. She served as an unpaid servant for several years as a minor. Her passport was confiscated. She worked very long hours and for many days without break. And there were tight restrictions on her movement. And she sought to rely on Article 4 of the European Convention, which provides a prohibition on slavery and forced labour. And she said, and put forward through her representatives, that she was acting effectively as a slave. Now, the court, in coming to its judgment, held that it could not be considered that the applicant had been held in slavery in the traditional sense. And the traditional sense was that they couldn't find that the respondent exercised ownership over her and that she was unable to change her status. So slavery remains a very high hurdle indeed. The court did, however, indicate that the applicants had at least been forced to subjected to forced labour and held in servitude within the meaning of Article 4. So servitude, the second term, covers a broader set of circumstances. Exploitation, taking advantage of individuals, but short of ownership. But it does require proof of circumstances where the individual was trapped effectively and had no choice to leave or change their circumstances. One helpful UK case on this is the case of Connors and others in 2013. Now, Connors was a prosecution involving a number of members of the Connors family. They owned a caravan park and they forced the victims to work long hours for little money, where the workers were subjected to degrading treatment. The victims were vulnerable, often homeless, and what each of them had in common was that when they first met the Connors family, they'd been unemployed and addicted to alcohol. So most had been homeless, relying on hostels. They had poor accommodation. Some, in fact, many of them suffered mental health difficulties. So all of them were vulnerable in some way. The vast majority of the workers, however, desperate they were for a roof over their head, realized their conditions were bad, they were at risk of violence, and the promised pay was not going to materialize. And they escaped, many of them escaped by running away during the night or disappearing when they were not being observed. Now, 5 of the Connors family were convicted of conspiracy to require a person to perform forced or compulsory labor. But the case overall is helpful again in showing where the dividing line is between different states of exploitation. So there, the trial judge withdrew the case from the jury, the issue of servitude, before they could consider it. because in the judge's view, to establish servitude, there was a high threshold that existed. And in order to convict, the court must find it was impossible for the worker to change status. So you then come on to the third element, if you like, forced or compulsory labour. As I indicated, again, there is a sliding scale of forced or compulsory labour. Again, a useful starting point if you're going to look at any of the case law is the Belgian case of Van de Muzel, 1983. It may strike a chord with some. It involved a pupil advocate providing free legal services. So Van de Muzel complained he'd been required to provide such services without getting proper or any remuneration or being reimbursed for his expenses, and that the judicial code in Belgium would make him liable to sanctions if he refused to represent the offender. And he argued that those circumstances gave rise to forced or compulsory labour. Now, the court there affirmed that the starting point for consideration of this was the International Labour Organization Forced Labour Convention. That dates back to 1930. And indeed, that is the starting point for the drafting of Article 4, which offered a definition as follows: all work or service which is exacted from any person under the menace of any penalty, and for which the said person has not offered himself voluntarily, may fall within that definition. Now, the court found against him in his complaints. So again, it's a helpful indication of where the dividing lines are and the thresholds that have to be met in relation to each. So the starting point, obviously, consider slavery, then servitude, and then forced and compulsory labour. And if you're tasked with drafting charges or considering an indictment or advising on how to proceed, think effectively in those terms. So having looked at that, can we go to slide 5? I think we skipped over it. Or is it 4? Human trafficking. So trafficking, human trafficking, essentially this involves the arranging or facilitating travel of another person with a view to exploitation. So as it says, it's concerned with the trafficking or movement of the individual. And it is irrelevant if the person consents to travel. Often such travel is accompanied by unkept promises. It covers trafficking into any country or within the country. In reality, if you are again tasked with considering a prosecution, what you would probably do, and I would say you should do, is consider this section first. So start with section 2, consider trafficking, the possibility of the movement of exploited individuals. And if you don't have or have insufficient material to support that, then go back to your section 1, slavery, servitude, and forced or compulsory labour. And again, there's no definitive definition of a trafficked victim. So they're identified as those exploited by traffickers and victims as identified by the Palermo Protocol. I think Szilvia's going to come on to that later. But essentially, a loss of freedom is a defining feature of trafficking. So people are often not allowed to leave premises, punished or subjected to violence. And exploitation is the key word, maybe the byword, when we consider this legislation altogether. Travel must be arranged or facilitated with a view, you can see, to exploitation of the individual. And note section 2.4, the reference to the exploitation being in any part of the world in both section 2, subsection 4a and b. And section 2.5, arriving in, entering, departing, or traveling within. So it's really there to cover the movement of exploited individuals across borders, within jurisdictions, and as I said, within jurisdictions, even that would constitute trafficking and fit within the section. So can we look at the next slide, please? So it's slightly confusing, but the slide you see contains subsections 5 and 6 of section 3. Now, section 3 hasn't been copied. in full, but it deals with circumstances of what may constitute exploitation, which, as I said, is an essential element for this offending. So in summary, a person is exploited in circumstances including where an offence is committed under Section 1. So going back to slavery, servitude, or forced or compulsory labour, which I've already touched upon, or in other circumstances. So subsection 3 would be for sexual exploitation, subsection 4, removal of organs, and then what you've got partly covered here, subsection 5, securing services by force, threats, or deception, and subsection 6, securing services from children and vulnerable persons. But in summary, what you're really looking for in cases concerning modern slavery under section 1 or 2 is evidence of coercion and deception. And the guidance such as it exists looks at evidence supporting those propositions, so coercion and deception. So where there's evidence of trafficking or under one of the section 1 headings, those matters of coercion and deception are critical. So what the case law has gone on to look at is, well, what are the factual circumstances that may assist? So if you're considering either prosecuting or defending, what are the sort of factors that might be adduced in evidence or relied upon to indicate modern slavery? Well, violence or threats, obviously, against an individual, threats against that individual's family, threats to expose the person to the authorities, withholding documents, identification documents, passports, general restriction of movement, debt bondage, withholding wages, and other things that might also be considered and properly adduced in a trial, lack of information given to the worker, excessive hours, hazardous conditions, the employer not paying their full tax liability, the absence of any clear contract, and then things like pure accommodation, the general sort of day-to-day treatment of these individuals who are being exploited, and very often with high rates of rent, and also isolation, because one of the things that is often a feature, of course, is that these individuals may come from countries abroad, they may not speak any good English, and they may effectively be isolated in this country. So in turn, they don't have the resources or the wherewithal to know where to go to, and they might be fearful of the repercussions if they do. So these factors supplement those matters already set out in statute under section 1, so the individual circumstances, and it goes on, you can see, to deal under section 4 with a further offence, which is set out of committing an offence with intent to commit an offence under section 2, trafficking. That's a bit of a mouthful, but just looking at what that means, that might include, for example, aiding or abetting, counselling or procuring an offence under section 2. And in reality, it might cover things like supplying false documents to assist with the travel for the purpose of committing a section 2 trafficking offence. So in those circumstances, you might then look at a section 4 type offence, a particular drafting of an offence under section 4. So Szilvia, I think back to you to look at the next slides.
Right, so I wonder if I'm off mute. I probably am. It's worth pointing out that both section 1 offences and section 2 offences carry the same maximum sentence, which is namely life. However, if your client, if you're defending, is being dealt with at magistrate's court, then obviously there are separate penalties limited to 6 months. And it's right to point out, as Richard has said, that there is a hierarchy of the offences under this legislation. And the hierarchy really is slavery, which is the most severe. And you can liken that to almost a right of ownership over a person. Next in line is servitude. And if you think about that, that's coercion to provide services where really the person doesn't have much autonomy or choice. And then forced labor, which is it's offered voluntarily but with conditions that perhaps they didn't sign up to, and it's the least severe. And although there is this hierarchy, actually, the courts don't deal with it in that way. And a good reason for that is, for example, if the exploitation is with the intent or for the purpose of a sexual offense, then the courts will take a view that sexual offending and exploiting sex workers or children for sex is, whatever the hierarchy of the servitude involved, a much more serious way of behaving towards another person. And also, as Richard has pointed out, that Section 4 under the Human Trafficking Act can be committed with a view to exploitation, even where no exploitation has taken place, as opposed to Section 1 offences, where there has to be actual forced labour or servitude that can be evidenced. So in terms of penalties, it's extremely wide-ranging. Two cases that I was involved in both relate to Romanian traffickers who brought Roma children, Roma women out to the UK who were already working in the sex industry in Romania. However, they were lured to this country under the pretext, in the case of one adult female, of a relationship with Mr. Marianescu. And he promised to look after her and be her boyfriend, provide her a safe place in the UK. And if she wanted to get away from sex work, she could find temping work, for example, with a UK agency. Well, that turned out to be a complete lie. And what he did was hand her over to actual traffickers who then, having in effect kidnapped her, put her into a brothel and put her to work on the streets of the UK. In that conspiring group of gang members, there was a much more serious offender. Her name was Miss Radu, and she was a madam who controlled a vast number of street prostitutes already in London. And her niche market was to bring Roma children over. So you can imagine that in terms of sentencing, although it depends on who you're trafficking over, who you're controlling and in what way, there is a massive distinction between offences committed against adults and those committed against children. And that was in fact the first UK case where the Modern Slavery Act was used to prosecute for a child sex offence. But it's wide-ranging because, of course, you've got lots of offences that are commercially motivated. So labor exploitation, we're seeing sentences of between 3 and 11 years. And again, that depends on how many workers, over how long a period of time, what sort of conditions, how much profit was made, what sort of industry it is, what sort of health conditions. And you only have to look at the cases that made this legislation. When you think about the Vietnamese and the Chinese people who were being brought over back in the day by the snakeheads route of trafficking, those are the days when this wasn't an enlightened legal landscape. And so many of those taskmasters, gangmasters got away with it in a way in which they never would now. Morecambe Bay is just a bad example of the utter devastating consequences when poor labor conditions, dangerous conditions, lead people who are otherwise desperate anyway to come and undertake this work. Those workers in particular were duped. They were told they were coming over, they were going to work in restaurants. Well, they never went near a restaurant. They were out there on the beaches when the tides were dangerous to work in, and they were cockle picking. And that's just one example of why this legislation and the penalties are so changed. There are hefty increases in penalties for the corresponding legislation that went before it. The penalties are also ultimately aimed at disrupting offending networks and to prevent exploitation. And so they have lots of other meaty post-conviction orders like securing assets, reparation orders, proceeds of crime. And Richard touched on this when you were considering, he's going to come on to talk about considering charges. But not every offense which can be charged under modern slavery can or needs to be constrained to that. You can see, if you're defending someone, that they're charged with not just a modern slavery offense, but then a number of other offenses that are tagged onto it. If there was violence in the course of, for example, controlling a brothel because a girl was coerced and kept in line with being beaten up if she didn't participate or she questioned the conditions, then an ABH could be added to the indictment and your client is facing that as well. In the case of labor exploitation, sometimes they use the workers to commit benefit fraud. So you can charge that separately and they face that separately. So you've got to be mindful, whichever side you're on, and Richard will come on to this from the prosecution side. But if the ultimate aim of the penalties is to prevent exploitation and to disrupt these offending networks, then you really have to be right at the interview stage. If you're defending a client, have your radars on full alert about whether the police are doing everything they need to do, whether they have the right people, and whether they're investigating the right offense and the right people offending. So there's lots and lots of case law. We're happy to provide it to you. There's no sentencing guideline. They tend to fall back on, so far as judges are concerned, with the substantive precedent legislation. So for example, if it's sexual exploitation, we're going to be looking at the Sexual Offences Act offense that is taking place and use those guidelines. But it's aggravated by the fact that there is this exploitation, that the victim is forced or compelled to participate. And so what we're seeing is, certainly in the cases of these Romanians, they were given 14 years each, and that's to reflect primarily that they did it on such a vast scale and that they deceived their victims. And of course, there was a child involved. So Richard, I think it is back to you on the charging.
Yeah, so as Szilvia said, several charging considerations. Generally, how do you approach it? A lot of people aren't familiar, still haven't dealt with this legislation. Well, there's the usual two-stage test, considering the evidence and then the public interest. If you're considering taking a case to prosecution, you're going to have to consider when the alleged offending took place, because if it occurred before the 1st of August 2015, which is when these offences came into effect, then you have to consider evidence in the context of the previous affected statutory legislation. So if it's trafficking, you might be looking at section 59A of the Sexual Offences Act 2003, which is trafficking for sexual exploitation, or it might be section 4 of the Asylum and Immigration Act 2004, trafficking for exploitation, and they were in effect prior to this legislation. So obviously as time ticks over from the 1st of August 2015, you're looking at this newer legislation under the Modern Slavery Act. Now, as time goes on, this complication is inevitably likely to become less relevant. But just to give you an example from my own experience, I was dealing with a case in 2019 in Canterbury involving the organised recruitment of vulnerable people from Eastern Europe. And it was an organised crime group. It involved recruiting in Eastern Europe, putting people into accommodation, putting them onto planes, flying them over, transporting them to accommodation, and then controlling them, and then controlling their work and living circumstances in the UK. Now, the offending started, in fact, back in 2005 and continued beyond this act coming into force. So you have to consider when the offending occurred and therefore how you capture it on your indictment. And hopefully this will become less complicated, but just to give you an insight, we ended up indicting conspiracy to traffic into the UK from 2005 up to the 5th of April 2013 under the Asylum and Immigration Act. and conspiracy to traffic within the UK for the same period. So that covered up to the 5th of April. But these older sections were then amended for a short period from the 6th of April to the coming into force of the Modern Slavery Act. So we had to then add 2 further counts under section 41A and B for that particular period, mirroring the earlier counts. And then finally 2 further conspiracy counts under section 2, the trafficking, which we've gone through under the Modern Slavery Act from the 31st of July 2015 to the time of the arrest in 2018. Now it sounds, and it was fairly complicated, but actually juries seem to understand the reason for the separate charges. But you must be mindful, of course, as you would be with any offending, of the time period. And this offending, as I've stated, took place over a number of years, but the law changed as time ticked by. And as I say, hopefully these sorts of problems will become fewer and fewer. Again, as Szilvia mentioned, remember to consider if you are drafting counts, if you're considering charging, it may be your offending is adequately covered by section 1 and 2, but consider additional counts. You might have other offending. You might have particular instances of assault, blackmail, false imprisonment, money laundering, and you might want to include these on an indictment. Of course, you balance that by keeping in mind you don't want to overload the indictments. You don't want to make things too complicated. You'll have to consider whether you charge substantive offences or conspiracies. So the conspiracies will often be effective where for example, you can't identify a particular person having controlled a victim at a particular time. You might also consider conspiracy to traffic where your case includes a number of different acts at times by different people, or where acts or some acts occurred outside of England and Wales, as long as those acts abroad would amount to offending here, and you'd need Attorney General's consent in those circumstances. Consider also, you now have under the Serious Crime Act 2015, section 45, another section 45, not to be confused with the statutory defence under this legislation, but under the Serious Crime Act, there is an offence of participating in the criminal activities of an organised crime group, and that is a standalone offence. So that is applicable itself to any offences after the 3rd of May 2015. And you might also want to consider, for example, section 4 of the Fraud Act 2006. That's the provision under the Fraud Act regarding abuse of position. And so, for example, if you've got insufficient evidence to establish exploitation, you might consider that. Also, the Children and Young Persons Act 1933, cruelty to persons under section 6, under the age of 16. So, a number of considerations you'll need to consider. Ultimately, the case, the particular case, you'll have to consider, and what is practicable. You'll also have to consider, we're not going to go into the detail of this, but special measures. What care do you take in relation to those complainants? Do you have to consider accommodation, ABE interviews, other special measures that might have to be put in place, interpreters, screens, anonymity orders, also whether you can arrange giving evidence from abroad by link. Again, my Canterbury case, we did all of those, and in fact, quite effectively. So these are important considerations and practical considerations when you're considering charging. So Szilvia, back to you.
Right, so the reason for all of this really comes down to the Palermo Protocols and the protection, the principle of the criminal victim, because Article 4 is the big one here. As humans, we all should have the right not to be held as slaves or work in servitude. And ECAT, which is the European Convention Against Trafficking, is something that the UK government has adopted and has a duty to uphold. And so this part of our talk really focuses for those who defend, and who defend at the very earliest stage, because it's now a very changed landscape. No longer can the prosecution just charge somebody, as Richard has looked at, against whom there is evidence. There may well be evidence, but unless the state has discharged its duty, even before you get to the charging stage, and can demonstrate that there are operational measures put in place that protect those criminals who are actually victims, then a prosecution shouldn't get off the ground. And the number of times that solicitors will go to a police station and it's quite clear to them that whether their client is charged with a sex offense or as a lot of, for example, trafficked Vietnamese clients are charged with drug offenses, being in factories growing where they are growing cannabis. The difficulty is that where an authority hasn't taken the precautions and demonstrated that measures have been put in place to protect people who are otherwise going to be exploited, and there's a very real risk that they are going to contravene their Article 4 duties. And so you should be aware of that at the earliest stage. And the Palermo Protocol makes it very, very clear that, especially where the individual is a child, you may not even get the cooperation of that child. That child may not even tell you that they are under duress. They may not tell you their background. You may not even know their age definitively. And so the duty really falls at the very earliest stage, should fall on the investigators. And after that, it falls on those who represent these people, because you've got to be able to look behind the offending. And that's really what the principles here are trying to address. Where authorities are aware that there is an industry, where there is a group of organized criminals that are operating in a certain way, then if they've done nothing to change their investigatory methods, where they've done nothing to put measures in place that filter out, rather than like large fishing trawls, those individuals who are also caught up in it because they are compelled to commit the offenses that are charged day in, day out, then they are going to contravene their Article 4 obligations. And when that happens, you need to raise, and Richard will come on to this, a referral to the national referral mechanism. John McGuinness was in fact involved in the case which rewrote the guidance that the CPS now have on all of this. And he's quite humble about his having done that. But the reality is that where there's a suspicion that a person may be a victim of trafficking, or potentially so, then at the very earliest stage, that case should not go ahead to the PTPH stage. And that is because victims or potential victims of trafficking under this convention and under our adopted duty have the right to be treated as victims if there's credible evidence that they are victims. And so both the Palermo Protocol and EU directives make this clear. And I'm not going to labor that, but anyone who wants better information about this, where the CPS simply refuse, or the police refuse to refer, and we have this a lot, those of us who defend vulnerable people, where there's a flat-out refusal by the police to get an NRM put in train, then counsel, by the time counsel get to it, you do have an abusive process. You have to do this in writing, you have to do it at the earliest stage, and you really should do it before he or she pleads. And I think increasingly, and we're talking about 10,000 people referred to the national referral mechanism, it should be faster than it's operating. But obviously everything has a backlog, so you're forever being told, well, we're not going to refer because it's such a long waiting list. It's crucial that you do. And if you get nowhere, abusive process would be my advice about it. But Richard, I will We're not going to have time for all the case law, I'm afraid, so we'll whiz past that. And it's on to Richard for the section 45.
So again, I'm just going to run through effectively what this is, but within the Act, there is a defence for individuals who are themselves victims of slavery or trafficking or exploitation. And the reality remains that even if practitioners have a vague familiarity with the Act, most people are not aware of the existence of the statutory defence, and it's not used perhaps as often as it could be. So this really is quite important, in particular for defence solicitors to consider as a potential line really at the outset of a case. Now, in seeking to advance the statutory defence for anyone, a different test applies whether you are an adult, whether the potential defendant is an adult or a child. And to successfully advance the defence, you need, if you're an adult, to show that the offence, that they committed the offence as they were compelled to do so, that the compulsion was attributable to their situation, that is slavery or the relevant exploitation, and that a reasonable person in the same situation as that person and having the person's relevant characteristics would have no realistic alternative to doing that act. So if you can establish that, you will have established a defence. And in respect of a child, the test is slightly different. It would be necessary to show that the offence is committed as a direct consequence of the person being or having been a victim of slavery or a victim of the relevant exploitation. And secondly, that a reasonable person, again, that test of the reasonable person in the same situation and sharing the characteristics would do that act. Now, the defence once raised does not provide carte blanche immunity or escape from prosecution, of course. And it does not apply to a number of offences. So, for example, serious violent or sexual offences are particularly excluded. And there is a full list of those set out in Schedule 4 of the Act. Now, the majority of cases involving Section 45 in the statutory defence would first be dealt with through what Szilvia's already touched upon, the national referral mechanism. Now, what is that? Well, that's a single framework centred on assessing individual cases to deal with matters referred to them from both victims and potential suspects. And the National Referral Mechanism, or the NRM, will first consider whether there are reasonable grounds to believe that the individual is in fact the victim themselves of modern slavery. And it is a low initial hurdle. And if it's met, then the NRM will move to the next stage. A child may be referred, and for adults, it's a voluntary process requiring their consent. Now, if it is considered that there are reasonable grounds, the NRM considers there are reasonable grounds, there will then be a further conclusive grounds hearing. Now, time frame wise, it's meant to take 6 or 7 weeks. In reality, it takes much longer. That may result in delays to legal proceedings going ahead, and it can run on for months. In reality, of course, particularly now, there is a lack of resources. There is also a lack of clear guidance, and decisions are not made in a consistent or indeed an efficient manner. If there is, though, a conclusive grounds decision that supports the defendant or victim's account of being themselves the subject of modern slavery, it's then a matter for the CPS to decide whether or not the code for Crown prosecutors, that test is met. Now, they have specific guidance to reach a determination. I'm not going to go through that now. But the important thing to bear in mind is that the CPS are not bound by the NRM's findings. The CPS decision may or will have regards to the decision of the NRM, but it must and is independent, not least because the NRM decision will not be made to the same standard of proof. It may rely on hearsay evidence or material that is otherwise inadmissible. So the CPS will take it into account, but they are not bound by that decision. And if the decision is to nonetheless go against an NRM decision, and there is a decision to prosecute. If you find yourself in the position either of prosecuting or defending, just be conscious of the fact that there are disclosure obligations, whether you're acting for one side or the other. The contact that an individual has with the NRM will almost inevitably lead to disclosure. If you're defending, seek full disclosure of that material. If you're prosecuting, take into consideration you will have to, in all likelihood, disclose that material, and indeed material of any contact with third parties that the individual might have. And in a trial, if the statutory defence is raised, just so it's entirely clear, if the defence raise the matter, it is for the Crown to disprove it to the criminal standard. And there is a case set out in one of the slides, the case of the Crown and MK 2018. So in effect, it's similar to, for example, raising and dealing with the burden with an issue of self-defence. Once it's raised by the defence, the prosecution have to effectively knock it down and to the criminal standard. There is quite a bit of guidance. There's Home Office guidance under Section 49 of the Modern Slavery Act, issued in March 2020, in terms of how to identify victims of trafficking. There's CPS guidance. There are other cases, and again, I think Szilvia touched upon it, but from the 22nd of July 2019 and Form PTPH2, there is a specific section now dealing with potential victims of trafficking. But it should be noted that the operation of the defence under Section 45, of course, does not provide a blanket defence for victims or alleged victims of trafficking. And also, there must be a nexus or a connection between the fact of having been trafficked and the alleged offence in order for an individual to avail themselves of the defence. If an individual happens to be a victim of human trafficking but has committed an offence completely separately and independently, of course, that defence would not be successful. Statistically and anecdotally, although NRM referrals have increased, so have the number of applications to the NRM which have failed. So it does not provide an easy out for defendants, but you must, I would suggest, if you're defending and you're involved in a trafficking case, it is something that you should certainly consider and consider right from the outset. Szilvia.
I'm going to skip the report on modern slavery. We just haven't got time, and move on to this, which is important. The real importance of the Queen against MK, that case, was what you can see there on the screen, this CPS and judicial skepticism of findings. So 3 things need to be pointed out. One is if you get a positive finding, you will not have reasons set out. They just tell you it's positive finding and there's very little that comes with that package. However, if there's a negative finding, you must be provided with robust reasons. And the reason I'm highlighting or putting emphasis on this is because if you're not given full written reasons that set out the reason why the applicant was rejected as a victim of trafficking, then you do have the right to go to the administrative courts for judicial review of that decision. And so it becomes important in cases where, for example, it's rejected because of an age assessment, because of a failure to apply their own policy, or the evidence on which the decision was taken it is in some way capable of being criticized, weak, or whatever. And so it's quite important that when there is a negative finding, that perhaps you don't take that at face value if you have your own reasons for suspecting that a client for whom you're handling a case may in fact be a victim of trafficking. I'll give you one really great example in which IBB solicitors Anna Ford and I use the NRM mechanism in a completely different way. At the end of the day, a positive and or negative finding when you go to trial courts have made it very clear, and it remains a matter of fact, that those are pieces of evidence for a jury to place reliance in. Whether ultimately it's successful, even where there is a positive finding at trial, in equipping your client with a defense remains a matter for the jury. As Richard has said, there's a great many number of offenses to which the NRM mechanism simply doesn't apply. But Anna Ford and I had a client who we suspected, because she was only 16 and she had been involved in a series of robberies with a very much older male defendant who had become her first sexual partner and relationship. She was enthralled by him and completely under his spell. And so she was, she had been convinced by him to participate in a number of street, very violent robberies. And so one thing that Anna really educated me in was to use trafficking experts. And so even if it's not for the purpose of getting an NRM so that it's a Section 45 defense, what we found that for this young girl at sentence, the courts are nevertheless obliged to take into consideration, even at that stage, how to deal with a defendant who is in fact a victim. And so I cannot emphasize this enough, that whichever way your NRM falls, that may not be the end of it. If you are absolutely convinced that the evidence that was considered wasn't sufficient, if you're convinced that the CPS or the NRM competent authority didn't follow their own guidance and policy, challenge it. Even where it can't be utilized as part of a defense, I still urge you to look around this principled approach to how we deal with defendants who are in fact victims, and think about deploying it even as part of mitigation. It did work, and whilst her older adult co-defendant got 5 years custody, our young defendant managed unbelievably to have her sentence suspended. And that was because the evidence of her exploitation by this older defendant was so completely capable of being documented. She had all the signs of being a victim. She was abused physically by him. She was sometimes not allowed to leave properties where she lived with him. She was sexually abused by him. And so she had all of the hallmarks, but we couldn't apply it to a statutory defense. However, and compassionately, the judge felt that it was her duty under these provisions and under these principles to nevertheless consider it. So where you have CPS or judicial skepticism, that's right. And that's what MK really was there for, because there were unmeritorious deployments of statutory defense, and that knocked it on the head. But then you had a situation where judges at Harrow and Isleworth, I came across them, they simply didn't believe the positive findings. And we got to the stage where, in fact, and I won't name the judge, demanded that the person who came to that conclusion come and give evidence at court. And the simple reality is, when there's a positive finding, there are going to be no grounds provided for that, no explanations. Only when the finding is negative, and what you have to understand is actually there's a process behind the NRM that is checking the negative findings. So I'm afraid when judges push back to that extent, you really have to argue either the Article 4 points or just argue robustly against that sort of thing. And I'm afraid we're running over. So we are probably not going to be able to cover everything, and it's Richard's birthday, and I promised him he could go at slide 12. But can I just say, there's lots of new law enforcement and joined up multi-agency developments afoot, which are all here to really give this ground a bit more of a thought-through approach. There are technological advances. For example, there's now AI that does translations quite quickly. That can be done in hours as opposed to months. And so if your client tells you that there is material on their phone or on their social media account which demonstrates that they have been a victim of trafficking, that demonstrates that they are in some way being exploited, urge it upon at that stage, at the police station, before the first appearance, for the investigators to look into it, because the technology is increasingly there, and increasingly there is joined up thinking about this from multi-agency involvement. But Richard, I'm afraid that's probably where we're going to have to leave it. And Ra, if you want to field questions and people want to stay behind, we're happy to do that. But I appreciate we're sort of getting into cocktail hour, so you don't want to.
Well, thank you both very much. I don't know whether it's now 10 past, well, it's 3 minutes past 7. I don't know if anybody's got any questions that they would like to ask either Szilvia or Richard. If so, unmute yourselves. I think Szilvia, because you are sharing your screen, which enables us all to see how praised you both are by the legal directories, it means that we can't see everybody. So if anybody was, for example, putting their virtual hand up, I'd have to be scrolling down to see it. So it might be better if you stop sharing, we could go to gallery view.
Okay, I don't actually know how to do that.
Well, don't worry if you can't, I'll just scroll through to see. But otherwise, if anybody does have any questions, unmute yourselves and ask away.
And they can also email in questions. We're happy to answer them at a later date.
But otherwise, Szilvia, as I've understood it, the presentation that you have given, you're going to make available.
The slides will be uploaded.
Right? Yep. Well, it may be everyone is just at the end of a long day. That may be it on the question front. Two things I have noticed in modern slavery is actually the lack of education of the police in their lack of awareness of it in so many cases, so that when you get a defense statement where modern slavery is raised, they are at sea about what that means for them. And secondly, that's not just the police. I've certainly had in the last case I was doing modern slavery being raised in the defense statement, but being raised when it wasn't an available defense to the charges that the defendant was actually facing. So do be aware that it's not a defense to everything.
Absolutely.